I'm here as Dean, and for those of you I haven't met, my name is Nathanson, and I want to welcome everyone from the Osgood community here, from the McMaster community, and from any other communities that have dropped in on us today for what is always a high point in our season of named lectures. This is, of course, the Emet lecture, which since 1976 has been a real fixture on the calendar at Osgood. It's an endowed fund that has always been meant to explore the wider implications and broader reaches of law, whether in ethics, in religion, in culture, in the history of the legal system. And since the partnership with the Nathanson Center, which has rejuvenated this lecture, of course it takes up themes of human rights, transnationalism, crime and security, and other pursuits that Nathanson has become so well known for advancing. And I, having looked at the outline, having had a chance to talk a bit with Samantha, you'll have a number of these themes touched on in the talk today. But for Osgood and for our research community, it's never just about the topic or just about the talk that we value this series so much for. It's the chance to bring someone to our community, have a chance to exchange ideas and perspectives, some mentorship and ideas, especially with our younger scholars and graduate students and collaborators outside the law school, always seems to flow, and these are relationships that continue long after the talk. So it's with that spirit that I bring my greetings, and again, great pride in the talents of the organizers to plan these, of course, months in advance, especially getting speakers to include this date on their busy calendars. And the last thing I'll say is no one ever comes to Toronto in January as part of just the glamour of their position. This is always a stop that is driven by the ideas and the people. And so it's, of course, especially warming to us, even on a snowy day, to come together for this purpose. And with that, let me turn it over to Professor Tanguay Renaud to speak on behalf of himself, the Nathanson Center, and tell you a bit more about Samantha. Thank you very much.
Yes, so good afternoon. I'm François Tanguay Renaud. As Dean Sawson has mentioned, I'm the director of the Nathanson Center here at Osgood. And today it's my pleasure to introduce Professor Samantha Besson, who is, and I don't want to miss her title here, Professor of Public International Law and European Law at the University of Fribourg in Switzerland, as well as the co-director of the European Law Institute at the Universities of Bern, Fribourg, Neuchâtel, again in Switzerland. So when I looked at Samantha's biography this morning, I realized that it would be simply way too long to narrate it all to you in this short introduction. In fact, it's breathtaking. I invite you to look at it online. It's monumental. But let me just share a few facts with you. Samantha holds quite a few degrees. A degree in Swiss and European law from the University of Fribourg and Vienna, and a Magister Juris in European and Comparative Law from the University of Oxford, a PhD in Law from the University of Fribourg, and a Habilitation, which is this quintessential continental degree that we don't have here in legal theory, and Swiss, Comparative and European and International Constitutional Law from the University of Bern. So basically, she's done it all, and she's also been a visiting professor at the University of Zurich, Lausanne, Duke, Lisbon, Harvard, and so forth. Now, obviously, I could not introduce somebody like Samantha without mentioning her colossal publication record. Besides publication in French, which I won't mention, and this, somebody called François should not just put the publications in French aside, but that's because look, a huge part of her work has also been done in English. And the book that introduced me to Samantha's work, The Morality of Conflict, Reasonable Disagreement in Law, which was published with Hart Publishing and is now a classic of legal theory in 2005, is one of these books that is this thick. You know, you think some people spend careers writing. Dan Samantha spent a few years writing her. And then she co-edited a number of books that have all become bestsellers, including Deliberative Democracy and Its Discontent in 2006, Legal Republicanism, National and International Perspectives in 2009. She co-edited The Philosophy of International Law, along, it's worth mentioning, John Tasiulis, who was a 2011 or Emet lecturer who's now at King's College in London. And more recently, she's been working on the Oxford Handbook on the Sources of International Law, and she's also completing a new monograph on human rights theory. So I think it's now fair to describe Professor Besson as a world leader in legal theory, specifically in human rights theory, as well as, I think, a friend of Osgood and the Nathanson Center. Professor Besson was last with us in 2009, when again she presented another phenomenal seminar on the legitimacy of human rights. But we wanted more. So what did we do? Well, first of all, we decided this year to welcome at the center a postdoctoral researcher, Alain Zisset. I should say Dr. Alain Zisset, but he's telling me that because he's from Switzerland, because he has not published his doctorate, I cannot call him doctor, but I will call him doctor. Dr. Alain Zisset, who was Professor Besson's doctoral student. This is serendipitous that this happens. And we also decided that we wanted the real thing, Professor Besson, to come back, and this time to deliver one of our most distinguished name lectures, the Emet lecture. And so today, Professor Besson is here to talk to us not so much about the legitimacy, but about the sources of human rights. And so we're delighted that, Professor Besson, you have accepted this invitation. We're delighted to have you with us today. So before I invite Professor Besson to the podium, a few notes about format. So Professor Besson is going to speak for about 60 minutes, she tells us, and we have the room until 4:30. So we'll have the balance of the time for questions. The event is being recorded, not only for our own purposes, like all our activities at the Nathanson Center, it's also going to be posted on YouTube, as well as the brand new Osgood Digital Commons. And so just be conscious of this when you're asking your questions. So, ladies and gentlemen, please join me in welcoming Professor Samantha Besson. Thank you.
Thank you so much, Francois, and good afternoon, everyone. It's very nice to be back here and to see so many friends and colleagues again. And thanks for coming despite the snow. I suppose snow's quite common for you, but it is cold weather for me as a Swiss. So thank you very much for this distinguished invitation. You've all received an outline, so you'll be able to follow the structure of my talk. I'll be talking for about 60 minutes, and then I'll be really pleased to get questions to dig deeper into this interesting topic. So, without further ado, let me start. The sources of international human rights law, as it is in force today, refer to the processes through which international human rights are created and or identified as valid norms of international law. This is how I will understand it. The sources of international legal human rights should not be conflated with their moral grounds or justifications on the one hand, or with the grounds for the legitimate authority on the other. Of course, as it is the case in any legal order, the three questions, sources of law, moral grounds of law, and grounds of the legitimate authorities, are related, but they will be, here in this lecture, kept separate for the sake of clarity in the exposition and discussion. So I'm happy to go back to those questions later, but I'll put them aside for now and focus on sources. A first superficial survey of the practice of international human rights law revealed that its sources differ from those practiced in general international law, and in particular from those listed under Article 38 ICJ Statute, treaties, custom, and general principles of law, on the one hand, and reveals also that its sources differ from those practiced in other regimes of international law, on the other. What I mean by differences in those sources is that they differ at least in some of their conditions and mechanisms. Importantly, the specificities of the sources of international human rights law need not imply the existence of new or distinct sources from those of general international law. They may simply imply derogations from the general regime of sources of international law, but also mere differences from the sources at play in some other regimes without derogation from the general regime. When differences amount to derogations, they may actually be justified, for instance by reference to the lex specialis principle in international law, or to the intent of the states parties. Other derogations may not be justifiable, thus raising the question of the autonomy of international human rights law as a self-contained regime of international law. There are, I will argue in this lecture, at least 3 features of international human rights law that account for its specificities in terms of sources and are reflected by those specificities. Those 3 features are, first, and that's the first part of the lecture, the dual moral and legal nature as rights and its reflection in the objectivity of sources. Second, the dual domestic and international legality as legal rights and its reflection in the transnationality of the sources. That will be the second part of the lecture. And finally, the universality as moral and legal rights and its reflection in the generality of the sources. So there will be 3 features discussed and their impact on sources, and the lecture will reflect those 3 features. In the conclusion, I will draw some implications of the proposed argument for international human rights law as a regime of international law, but also for the sources of international law in general. So the sources of international human rights law are a central question for human rights, be it for the existence of international human rights law in itself, or by extension, and I've already said so right at the beginning, for its validity, its legitimacy, and its relationship to domestic law. Curiously, however, the sources of international human rights law are not a central concern in international human rights scholarship, or no longer a central concern in human rights law scholarship. They used to be at the heart of debates post-war and until the 1980s, but they're not anymore. And this is true for international human rights lawyers' accounts as much as it is for human rights theorists. Now, various reasons for this temporary or recent neglect may be ventured. First of all, and although there are exceptions, of course, human rights theorists remain, by and large, not interested in the technicalities of human rights law. Turning to lawyers now, most human rights lawyers take the difference between sources of international human rights law and those of general international law for granted. Human rights law is different, and we'll start from there. Conversely, general international lawyers draw very rarely on international human rights law to develop and systematize what could be described as a general international law on sources. They assume, indeed, and often a bit quickly, that the sources of general international law are well established and free of controversy. As I will explain, many of the disputes on the sources of international human rights law actually shed light on 2 controversies still lingering in the sources of general international law. Second reason for this neglect in the literature, and this is not unrelated to the first one, the relationships between general international lawyers and human rights lawyers are sometimes dominated by mutual disdain. This is well captured by the French phrase droit de l'hommisme, or human rightsism, as it was first coined by Alain Pellet, and referring to some human rights lawyers' unwarranted claim to specificity and even to rectitude in general international law. Worse, while international human rights lawyers are often pigeonholed by other international lawyers as natural lawyers, general international lawyers are in return often boxed as positivist lawyers. As I will explain later, however, there's nothing in the nature and content of human rights that makes international human rights law necessarily less positive than other international law norms. Such labels are all too often regrettably there to preempt, I think, any serious discussion of the sources of international human rights law and international scholarship. So that's my impression of why the question has stopped being a concern in scholarship. Before starting with the argument, I think I owe you a brief methodological caveat. This lecture does not claim to list and present all sources of international human rights law in an exhaustive and systematic fashion, as one would maybe in a human rights law class. Instead, it approaches the question from the perspective of human rights theory, and more precisely from the perspective of a legal theory of human rights. It starts from the practice of international human rights law and aims at providing the best interpretation and justification thereof, one that puts the practice in its best light. To that extent, and first of all, the lecture does not aim at proposing an independent moral theory of human rights and its sources that could then be used to reform the existing practice of international human rights law. It's not about imposing a moral blueprint onto that practice. There are plenty of examples of wishful thinking in international human rights law textbooks, and the point is not to do the same. Nor, however, is the lecture, secondly, about reconstructing the practice as a theory, and hence merely about justifying the practice. The danger with such a method would be to read too much in the practice of international human rights law, and the result would be apologetic or reductive. Instead, I think it's essential to understand that the practice of international human rights law entails its own immanent justifications and critique, and those are the justifications and critiques that need to be identified and interpreted in the proposed theory of the sources of international human rights law so as to best fit the practice while justifying it and criticizing it at the same time. Now, since the proposed theory of sources of international human rights law may be read as a sub-doctrine of sources of international law, the question I will and have to address in the conclusion is how it fits or does not fit the general doctrine of sources of international law, and why. Of course, since the practice of the sources of international law, including those of international human rights law, is structured in part by our doctrinal categories, there may be an inescapable degree of virtuous circularity between how we interpret and account for the practice and the practice of sources itself. But that's because sources is such an interesting and central topic. So that was my introduction. And I hope you're now clear about the topic, about what I will be addressing, what I'm not addressing, and how I will be addressing it. So let me move to the first section, the moral and legal nature of human rights and the objectivity of international human rights law. The first feature of human rights to be reflected in the sources of international human rights law is, I would like to argue, the equality of rights, and more specifically, the dual moral and legal nature of rights. This feature has implications, I will argue, for the sources of international human rights law that are best captured as reflecting the objectivity of human rights. So first, human rights as moral and legal rights. Human rights should be regarded as rights and as being at once moral and legal rights. First of all, human rights are rights. The practice of international human rights law treats human rights as rights. Of course, sometimes human rights go by other names, such as principles, but in most cases, legal human rights reasoning is expressly rights-based. Reasoning with reference to claims, interests, and duties. So I will, from now on, regard human rights as rights. Secondly, human rights are, I claim, at once moral and legal rights. Qua rights guaranteed by legal norms, international legal human rights are clearly legal rights. Just as moral rights are moral propositions and sources of moral duties, legal rights are legal propositions and sources of legal duties. In fact, the moral interests recognized by the law are sufficiently important to generate moral duties. And the same may be said of legal human rights. Legal human rights are fundamental and general moral interests recognized by the law as sufficiently important to generate moral duties. The question, which some of you are familiar, is now whether human rights, qua legal rights, are also and at the same time moral rights. Generally speaking, all legal rights are also moral rights. Legal rights recognize, modify, or even create moral rights by recognizing moral interests as sufficiently important to generate moral duties. As such, I will regard legal rights as always being moral rights, whether by recognition of pre-existing moral rights or by creation of moral rights through the legal recognition or legal creation. Of course, there may be so-called legal rights that do not actually protect pre-existing moral rights or even create moral rights. And in such cases, they will only bear the name of rights and will only generate legal duties and will not generate moral duties. The reverse is not true, however. All moral rights are not necessarily also legal rights. Some moral rights can exist independently from legal rights. In fact, there may be ways of protecting moral interests or even independent moral rights legally without recognizing them as legal rights. So how about human rights then? Well, like other legal rights, they're also moral qua rights. But unlike moral rights, they should also be legal. The universal moral rights that will become human rights create moral duties for institutions, and hence for the law as well, to recognize and protect human rights. This is the only way, as I've argued elsewhere, to give them the essential egalitarian dimension and to assess, for instance, whether the interests and threats at stake to be protected by human rights are generally social comparatively, and to specify and allocate the corresponding duties in an egalitarian fashion. So in short, human rights, qua subset of universal moral rights, are of an inherently legal nature. While legal rights stricto sensu are necessarily moral, qua rights, human rights, qua rights, are also necessarily legal, and they are as a result both moral and legal rights. The law turns universal moral rights into human rights, either by recognizing them as legal rights or by creating them in recognizing certain fundamental universal moral interests as social comparatively important. The law is an integral part of the institutional and relational nature of human rights, and without the law, there could be no human rights. This understanding of the relationship between moral and legal human rights is actually one of mutuality. It goes beyond the traditional understanding of a unilateral relationship of translation, transposition, or enforcement of moral human rights through legal human rights. It goes both ways. Importantly, there's nothing in the relationship between moral and legal human rights I've just presented that makes international human rights law necessarily less positive than other international law norms. The opposition between natural law and positive law, or more exactly between just naturalism and legal positivism, is one between theories of validity of law, and in particular of the latter's dependence on morality or not. Legal positivism, as I understand it here, is the view that the grounds of law are a matter of fact and not of morality. Considering that a legal norm corresponds to a moral norm, or more indirectly to some moral value, provided this is not its ground, does not make one a natural lawyer. True, international human rights law is very clear about its moral ties. In fact, it refers expressly to the independent existence of moral justifications for human rights, and actually to various potential justifications. It does so mostly in preambles to human rights treaties, for instance by reference to dignity, you had a lecture on dignity, by reference to equality or autonomy, and by using foundational or derivational language. This is not surprising, however, albeit maybe a little more explicit than in other areas of international law. Moreover, there's nothing there that tells us anything about the grounds of international human rights law and how it becomes valid law, thus allowing for it to be posited like the rest of international law. In short, the claim about the absence of conceptual connection between international law and morality does not equate with the claim about a lack of factual connection. On the contrary, there's often a clear continuity and factual relationship between law and morality, as it is the case in international human rights law. Now, why is there a difficulty? Well, there is a difficulty in international law because of the false association between legal positivism and consensualism or voluntarism, i.e. the view that the content of international law flows from state consent. And this false association between legal positivism and consensualism is held to imply not only a stark separation between law and morality, but also the absence of factual relationship between law and morality. It's important, however, to dispel the idea that legal positivism should be associated with state consent in international law. The ties between legal positivism and consensualism are historical, they date back to Grotius, but are not warranted conceptually, nor are they factually either. International law may be posited without state consent, for instance through practice in customary lawmaking. By extension, in international human rights law, it is not because some of the sources of international human rights law are or have become independent from state consent, as it is the case with general principle, that international human rights law is to be equated with natural law. nor should a legal positivist account of international human rights law of the kind proposed in this lecture necessarily be consensualist. So that was for my first point about the nature of human rights as moral and legal rights, and about the importance of not confusing this argument with an argument of natural law. Now let me move to how this can then be reflected in the sources of international human rights law. That's my point B, international human rights law as objective law. The dual moral and legal nature of human rights is reflected by the sources of international human rights law, and in particular by their objectivity. Unlike domestic law, international law also includes norms whose normativity may be regarded as consensual or subjective, and that are more akin to promises and contracts than to non-consensual or objective law. While some of the sources of international law accommodate both kinds of normativity, like treaties, others do not. Customary international law and general principles, for instance, do not rely on consent and the exchange of promises. The objectivity of international human rights law may be illustrated by reference to three characteristics in its sources: the legislative dimensions of human rights treaties, the importance of general principles and hence of judicial reasoning, and 3, the role of soft law. For time constraint, I will not discuss the role of soft law. It's on the outline, and I'm happy to discuss it in the discussion, but I will skip part 3, just for those of you who are following closely as I speak. So let me turn to my point 1, the legislative dimensions of human rights treaties. Human rights are protected by multifarious multilateral treaties, some universal, potentially so, adopted within the United Nations, and others regional, adopted within the Council of Europe, the Organization of American States, or the African Union. While those treaties are concluded as treaties and should, on the face of it, comply with the international law on treaties, and especially the 1969 Vienna Convention on the Law of Treaties in particular, the practice of those treaties has gradually demonstrated various features that one may associate with the characteristics of legislative treaties by opposition to contract-like treaties. What so-called legislative treaties have in common is that they've gradually emancipated from states' parties' mutual consent and from the structure of reciprocity induced by the constitutive exchange of consent, and hence have emancipated from the structure of mutual duties, thus revealing quasi-legislative traits. In the case of human rights treaties, the legislative characteristics have, I think, a twofold origin. First, human rights treaties grant rights to individuals who are not parties to the treaties and hence do not give rise to interstate duties. Second, human rights treaties give rise to duties that are not owed to people under the jurisdiction of another state party, but to people who are under the jurisdiction of the respective state party itself. So, while there are other international treaties that grant direct individual rights, human rights treaties are the only ones whose main content it is to do so. Moreover, the rights protected by human rights treaties are not mutually recognized, and hence the object of an exchange, as it were, by the states' parties. Those states do not owe human rights duties to people under the jurisdiction of other states' parties, whereas they do in other treaties that grant individual rights. It suffices to think of treaties on consular or diplomatic relations, on immunities or economic law, to see that the fact that the person to whom duties are owed is under the jurisdiction of another state is central to those treaties, whereas it is not central to human rights treaties. So more specifically, I think there are at least 3 legislative features of human rights treaties that reflect the objective nature of the rights and duties they generate. First, the validity and severability of reservations. Second, the continuity of human rights treaties. And 3, the erga omnes effects of human rights treaties. I have to say that I know that some of you are more philosophical or belong to philosophers more than to international lawyers. Well, I know that others among you belong to the international law crowd, so I hope this is not getting too technical, but I think it really makes sense to get into the details to see how the argument actually hits. So I say there are three legislative features of human rights treaties. Those features relate to reservations, continuity of human rights treaties, and erga omnes effects of human rights treaties. And my claim is that they all reflect the dual moral and legal nature of human rights. So while some of those features are licit under the VCLT, the Vienna Convention on the Law of Treaties, that is generally open to international derogations by states parties or to derogations based on the object and purpose of the treaty, others have developed despite contrary rules or principles in the VCLT. So let me first take reservations. Under Articles 29 to 23 of the VCLT, state parties may, under certain conditions, file reservations regarding the applicability of treaty provisions to them. Reservations to human rights treaties, by contrast, have triggered a divergent practice and hence stirred an interesting controversy, both with respect to their validity and their severability. At the outset, I should say that in the VCLT system, in principles, other states parties assess individually the validity of another state's parties' reservations to their treaties, including multilateral treaties, and may object to them individually. In the case of human rights treaties, however, international human rights monitoring bodies, be they judicial, so courts, or non-judicial, treaty bodies, have centralized that competence. Now, the centralizing of the competence to assess the validity and to object to the reservations to human rights treaties is not per se contradictory to the VCLT. In fact, I think it may even be justified by reference to the objectivity and hence collective nature of the interests at stake here. Very few states have objected in practice to reservations to human rights treaties. They simply do not have an individual interest in doing so, distinct from the objective interest to preserve the integrity of the treaty. And the latter, the interest to preserve the integrity of the treaty, is a collective interest that they often fail to act upon on their own. So, let me now present the validity and the severability of reservation and show you how the practice for human rights treaties is divergent and how I think we can justify this by reference to the objectivity of human rights. So first of all, the validity of reservations to human rights treaties. Under the conditions of Article 19 VCLT, reservations are deemed invalid in cases they are prohibited by the treaty itself or are not compatible with the object and the purpose of the treaty. By contrast, in the case of human rights treaties reservation, the validity has been questioned even outside of those two possibilities. This has been the case by the UN human rights treaty bodies, such as the Human Rights Committee, but also by the European Court of Human Rights. They've all expressed doubts at the compatibility of reservations in general, and this despite the fact that those treaties do not exclude reservations and even grant the possibility of filing some. The first argument for the limited validity of reservations to human rights treaties has been that human rights treaties often give rise to imperative or at least stringent duties, and that their object and purpose is per se incompatible with reservations. This argument cannot be accepted outside of reservations to non-derogable or absolute rights, for most human rights may actually be restricted, provided justifications are given. As a matter of fact, with respect to the former, Article 19 VCLT, read in conjunction with Article 53 VCLT, includes the violation of jus cogens as an implicit ground of invalidity of reservations. Of course, one may always argue that the scope of jus cogens norms under Article 53 VCLT does not necessarily match that of absolute human rights or absolute core duty to those rights, and I think we can discuss this later if you want to. So the first argument about the non-derogability of some human rights, I think is not decisive, precisely because it is warranted for by the VCLT and not all human rights duties are imperative. A second argument that's more serious, I think, may be that restrictions to human rights, although they may be justified, are concrete and not abstract or blanket restrictions of the kind allowed by a reservation. One may argue, therefore, that the justificatory requirements stemming from human rights treaties' restriction clauses, or implicit to them in practice, actually require a concrete reasoning and balancing, and that balancing cannot be abstractly preempted through ex-ante reservations. This may explain why, among the conditions for reservations to human rights treaties, one usually finds a justification requirement in the light of domestic law, as if the blanket restriction that a state request were to be specifically justified because it would preempt a concrete justification in each case. This also accounts, I think, for why international human rights bodies and courts understand reservations as limited in time, for instance, and see themselves as entitled to regularly press states party to withdraw their reservations, even when they have been considered as valid. So I think the second argument flies. A third and final argument for the limited validity of reservations to human rights treaties is that some human rights may also stem from sources of international law that are not consent-based, like customary international law or general principles. So consent to a reservation cannot justify restrictions to customary human rights duty that does not allow for reservations. This is an interesting argument, but I think it only pertains to the customary duty and not to the treaty duty. So it doesn't actually work as a decisive argument. So that was for the validity of reservations to human rights treaties and the arguments I think we can bring for why they submitted to a different regime. Secondly, the severability of reservations to human rights treaties. Under Articles 2021 of the Vienna Convention, each state party may object to reservations to a human rights treaty. By contrast, international human rights courts and bodies have decided that a reservation to a human rights treaty deemed invalid could be severed from the treaty without the latter's validity being set in question for either of the parties, including the reserving state, and with all its provisions, including the one concerned by the reservation. This practice contradicts the state's parties' individual right to either object to the entry into force of the treaty or to accept it, but without the provision. Now, the argument for this derogation is, I submit, that unlike other treaties, human rights treaties do not give rise to reciprocal duties, as I explained beforehand, but to objective duties. This feature undermines indeed the whole purpose of the mutual acceptation of reservation, that is to re-bilateralize multilateral treaties. If I'm right about the objective or non-reciprocal nature of international human rights law and the legislative features of human rights treaties, it would make absolutely no sense to want to bilateralize relations between states parties to a human rights treaty. So that was for the reservation questions. The second issue, or the second legislative feature of human rights treaties that needs to be accounted for and that I'd like to justify based on my objective account of human rights is the continuity of human rights treaties and the continuity of human rights treaties obligations. Article 60, paragraph 5 of the VCLT excludes the termination, suspension of human rights treaties for breach of the treaty. This is usually understood as a consequence of the non-reciprocal nature, and their continuity may be justified by reference to the objectivity argument I've made before. The problem is that there are two further features of the practice of human rights treaties that confirm their continuity and hence their objectivity. But those two features contradict the VCLT. The first one is the automatic succession to human rights treaties, while the second one is the non-denunciability. Both features are controversial, for they're not explicitly foreseen by the VCLT, but they fly into the face of the little international succession law there is and of explicit denunciation clauses that one finds in human rights treaties. So in response, I think we should say that international succession law is ridden with controversy and that there is, after all, very little coherent practice to refer to. As to explicit denunciation clauses, they've never been acted upon by states parties. While this may be for other strategic or legal reasons, such as the concurrence of customary human rights law, the lack of application of those clauses in practice is telling, and I think confirms the objectivity reading and the non-reciprocity reading of human rights law. My third point under the legislative features of human rights treaties pertain to the erga omnes effects of human rights treaties. Under the VCLTs, treaties have no third-party effects, not even to the extent of granting rights to states that are not states parties. Although the third-party effect of an international legal norm is not clearly or mainly a question of sources, it matters here for our understanding of the objectivity of human rights treaties and the specificities under international treaty law. There are two specificities I'd like to mention. First of all, and as I explained before, human rights treaties grant rights to individuals who are not parties to the treaties. Those rights are rights towards the states parties under whose jurisdiction they are. So that's a first very, very important divergence from the VCLT. The second one, and that's the one I will be addressing most, is that although states parties' duties are not reciprocal in a human rights treaty, to the extent that they do not owe each other the human rights duties they owe to the people under their respective jurisdiction, states parties to human rights treaties owe distinct duty for the respect of their human rights duties to all other states parties. In turn, the latter have rights that those human rights duties are respected domestically, albeit not rights to those duties directly, because they're states. So this is what is commonly understood by the erga omnes character of human rights duties. Interestingly, the term erga omnes is used for obligations owed to other states among states parties as much as to other states outside of the scope of states parties. This effect, this erga omnes effect of human rights duties, makes states parties to human rights treaties second-order rights holders. They have rights together that those people under the jurisdiction of other states parties have their human rights recognized and protected on the one hand, and the latter states parties have duties towards all other states parties to owe human rights duty towards people under their jurisdiction on the other. Importantly, those second-order rights and duties do not have the same content as the human rights and duties they pertain to, nor, and I repeat myself, are they reciprocal rights and duties between states. Evidence for those erga omnes obligations of states parties to human rights treaties is that states parties can be held responsible by other states parties or even third states, including through interstate complaint mechanisms, whether before international human rights courts or treaty bodies. Of course, and that's the usual objection, those mechanisms are often optional, and even when they're not, they're rarely used. Now, I think the reason for this lack of effectiveness of those interstate mechanisms may be precisely their prima facie contractualist flavor of reciprocity and the fear for the consequences of that reciprocity that states have. But this is a mistake. Those mechanisms should rather be understood to reflect the objectivity of international human rights law, whereby every other state shares an objective interest in holding others accountable for the violation of their human rights duties. Evidence for this may be found in the admissibility conditions, for instance, of interstate applications. States do not have to be victims of a violation of the right they invoke, and the mere violation of human rights of individuals under the jurisdiction of another state is enough to trigger the right to file that interstate application. Now, at this stage, some authors have contested that all international legal human rights have an erga omnes character. Following the International Court of Justice and its infamous identification of some human rights imperative and erga omnes features in Barcelona Traction, those authors confirm that this should be the case, so the erga omnes effect should be the case at least for imperative human rights, and they're ready to extend it to some other human rights, but not to all of them. Two arguments, I think, may be made in response and to the effect of granting all international legal human rights erga omnes effect. First of all, there's a distinction between having a right and actually benefiting from procedural mechanisms or remedies to enforce it in practice. One should not draw too much from the distinction between a state's diplomatic actions available to protect its right to exercise diplomatic protection and that state's second-order right to the respect of human rights. Remember that the right to diplomatic protection pertains only to one state's nationals and not to those of the other states, thus undermining, I think, the potential overlap between the kind of erga omnes duties and mechanisms I'm thinking of and diplomatic protection. Secondly, the lack of translation of the erga omnes character of human rights duties into automatic standing in international procedures, where standing is still optional, cannot be held as an argument against that character. There's still a general, albeit regrettable, separation between substantive norms and procedural remedies in the international legal order. And holding this against international legal human rights would, I think, be unfair. So I've now covered what I think are legislative features in the treaty practice of international human rights law, and I hope accounted for those features on the basis of the objective nature and the dual moral and legal nature of human rights I've been presented before. The second specificity of international human rights law sources that I'd like to discuss under this first heading of the objectivity of human rights is the importance of general principles of human rights law. General principles of international law are traditionally divided into two groups: general principles of law and general principles of international law stricto sensu. The first ones are principles that are fundamental to domestic legal orders and that may be extended to the international legal order, whereas general principles of international law, by contrast, are principles that are fundamental to the international legal order itself. The first group of principles, so general principles of law, is the one envisaged by Article 38 as a source of international law. International legal practice, however, has quickly recognized the existence and significance of the second group of principles as well, general principles of international law. Albeit, and this is interesting, not necessarily as a source of international law, but merely as a type of norm of international law stemming from other sources of international law. Importantly, however, the case law does not clearly distinguish between the two types of general principles and hence between their sources. And authors have actually ventured that the ICJ, the International Court of Justice, does so when referring to general principles, so not distinguishing between the two groups of general principle, precisely in order to escape the strict conditions of customary international law on the one hand, but without trying to link them back to domestic principles either on the other. So basically the ICJ is pleased with mentioning general principles without telling us whether it is as a source or merely as a type of norm. As a matter of fact, the conditions for the identification of the first group of general principles are still very vague in the ICJ's case law. The method used by other international courts is based on comparative law or legal analogy, but is not very strict. As to criteria, I think we can distinguish two. First, the generalizable nature of the principle that ought therefore to have been recognized legally in most states in the world. This is what we call the generalization condition. And second, the transposability to the international level by reference to the framework and objectives of the international legal order. This is what we call the adaptation condition. So this was meant to remind you about how controversial general principles are, tout court, as a source of international law. General principles correspond to objective norms of international law, whether in content or source. They don't depend on consent. It should not come as a surprise, therefore, that in practice, the sources of international human rights law also include, besides human rights treaties, some general principles. Evidence for this may be found in many ICJ decisions, whether they are antecedent or posterior to the adoption and development of conventional international human rights law. Sometimes this reference to general principles by the ICJ has explicitly included a reference to the principles in the Universal Declaration of Human Rights, presumably through their preexistence or recognition in domestic bills of rights, thus confirming at least that Universal Declaration of Human Rights are recognized as general principles of international law. So far, so good. The question, however, whether those principles are actually a source of international human rights law and not merely a type of norm used in that law remains open, not the least because the nature and role of general principles in international law are themselves disputed, as I've just explained. Now, here are, I think, some of the arguments one could bring in favor of recognizing general principles as a source of international human rights law. First of all, general principles do not depend on interstate practice for their existence as a source of international law. Given how difficult it is to provide evidence of an interstate practice in international human rights law, because human rights apply within domestic jurisdictions only, on the one hand, and because human rights duties are not owed to other states directly under human rights treaties on the other, that's what I explained before, then the reference to general principles in domestic law is easier to establish than the equivalent customary law principles. Second, and a more positive argument, is that much international human rights law fits the two criteria I presented for the identification of general principles as a source of international law. The ascertainment of domestic legal recognition does not need to be practice-based for a general principle to be recognized and can rely on declarations, such as a Bill of Rights or a Constitution, statements, or instruments of ratification. Thus, even without being respected on a regular and coherent basis, some human rights may be regarded as generally recognized as general principles domestically. Of course, a common objection against this argument is that some states do not actually recognize human rights principles in their domestic law. So the problem is not so much that they don't practice it, but they don't even recognize it. In reply, one may say that general principles need not be universal to be general principles. Some degree of generality is sufficient in practice, based on the representativity requirements applicable in the Human Rights Council. One may refer to the 5 regional groups from whom the members of the Human Rights Council are elected. Within each group, it would be enough to find some degree of generality of the intrastate human rights practice and non-unanimity thereof. I realize this is still hard to achieve, but I think it's more achievable than expected. Finally, a final argument for the recognition of general principles as a source of international human rights law, the largely domestic and international judicial nature of general principles of international law is particularly suiting in international human rights law. As I will argue next, adjudication plays a central role in the transnational development of human rights. Under Article 38 statute, ICJ statute, general principles have to be recognized by domestic institutions, usually courts, and then ascertained as sufficiently general and transposable to the international level by another court, this time an international court. So courts are necessary for general principles. This is something we've long established domestically, and it's not different internationally. Since human rights reasoning may be considered a special form of moral reasoning, and since judicial reasoning of all forms of legal reasoning comes closest to moral reasoning, the judicial dimension of general principles make them a source particularly suited to the objectivity of international human rights law. So, as announced, I'll skip the soft law section, but I think you got a sense of what this first section wants to achieve after establishing the objectivity of human rights. It tried to show how this accounts and justifies some of the seemingly derogatory features of international human rights law in practice in the context of their sources. Second step, or second section of the lecture, the dual legality of human rights and the transnationality of international human rights law that reflects that dual legality. The second feature of human rights I claim to be reflected in the source of international human rights law is a dual legality of human rights. Human rights are best interpreted as having to be both domestic and international legal rights. And this accounts, I think, for the transnational dimensions of the sources of international human rights law. So as in the first section, I will first argue for this dual legality, and secondly, bring you step by step through some of the characteristics of the sources of international human rights law that I think reflect this duality. Based on the interpretation of human rights as being at once moral and legal rights, the next question is whether the legalization of human rights should take place at the domestic or at the international level. Prima facie, of course, international law offers the kind of universal scope that matches that of universal moral rights and would seem to be the right locus for the legalization of human rights. However, given the interdependence between human rights, political equality and democracy that I've argued for, the political process through which the legalization takes place, I think, ought to be egalitarian and public, and hence include all those whose rights are affected and whose equality is at stake. This would favor, then, by contrast to the first hinge, this would favor domestic law as democratic law, as the right locus for the legalization of human rights. Of course, human rights law should also constrain those democratic communities in return, and cannot merely be defined by domestic, albeit democratic procedure. Now, this is a well-known tension between international legal human rights and domestic democracy, and it's one of the many complexities of human rights. Interestingly, I think that the egalitarian and hence democratic dimension of human rights and the seeming tensions this creates is reflected in the way in which international human rights law developed, through the practice of democratic states, but in a way of transnational consolidation of that practice into international law that gradually constrained their domestic practice in return. Historically, indeed, much of the content of international human rights treaties, and the UDHR in particular, was drawn from domestic bills of rights in 1945, and many of the latter were then revised post-1945 to be in line with the former. This virtuous circle has been perpetuated since then in the way in which domestic and international legal norms pertaining to human rights have been interpreted and developed together. Despite sharing the same structure, international human rights are not redundant with domestic human rights law, nor, however, are they merely there to fill the latter's gaps. On the contrary, international human rights law fulfills three functions that I think make international legal rights interdependent with domestic human rights and necessarily arise and function together. First function, a substantive one. It requires the protection of a minimal and abstract content of those rights against domestic leveling down and works, therefore, as a form of backup. Secondly, a personal one. It requires the inclusion of all those subjected to domestic jurisdiction, territorially or extraterritoriality, and whether they are nationals or not, in the scope of those rights. Third function, a procedural one. It requires the introduction of both domestic and international institutional mechanisms of monitoring and enforcement of those rights. Okay, so based on this argument of the democratic nature of human rights, I think we see and establish clearly that the legalization of human rights should be both domestic and international at the same time, and the practice of human rights law confirms this. So what does this mean in terms of sources? Well, I think the complementarity between domestic human rights law and international human rights law that I've just very briefly explained is reflected in the sources of international human rights law. As I've expressed it elsewhere, international human rights law and domestic human rights law are in a relation of mutual validation. This is reflected, for instance, in the way international human rights norms are inserted in the domestic legal order. Unlike other international law norms, international human rights law claims and is usually granted immediate validity and direct effect in domestic legal orders, independently from the latter's monism or dualism, and also usually a higher level of priority within the domestic legal order. This occurs mostly through the joint and largely indiscriminate application of international and constitutional human rights law by domestic authorities, and in particular, domestic courts. Now, this consolidated or dual corpus of international and domestic human rights may also be referred as transnational human rights law, or as others have called it, transnational constitutional law. The idea of a transnational set of constitutional rights corresponds to the way in which international human rights law apply in priority in the domestic legal order, albeit in all domestic legal orders at the same time. Evidence of this transnational process of mutual application and consolidation of human rights abounds, but the contours of this process of mutual application and consolidation remain under-theorized. Although the practice is largely irregular, I think what we observe is that what's used mostly to actually get this process of mutual application and consolidation going is some form of comparative constitutional law. And one key question that arises in this respect is whether this transnational process of mutual validation that I've just argued for gives comparative constitutional law a particular claim to legitimate authority beyond the usual justification one gives for it. So beyond the idea that comparative constitutional law has an informative or persuasive authority, or that it contributes to conceptual clarification. I actually think that explained through this transnational process of mutual validation, comparative constitutional law actually receives the democratic legitimation that it's long been refused, because as you all know, one of the most standard argument against comparative constitutional law is precisely that it lacks democratic legitimacy because it brings solutions from one domestic jurisdiction into another. Whereas based on this account of transnational human rights law that I've just described, I think we can provide comparative constitutional law with a kind of indirect democratic legitimation it lacked or was not given. Now, scope precludes addressing all those aspects in this lecture, so the only thing I wanted to do in this first letter B of the outline is just give you a brief understanding of how I understand the term transnational and the idea of transnational human rights law. What I'd like to do in the rest of this section 2 is take two features of the sources of international human rights law again that exemplify this time not so much the objectivity of human rights law and its dual moral and legal nature, but this time exemplify the transnationality and the mutual validation between international human rights law and domestic human rights law. And the two features, the two specific features of the sources of human rights law I've taken are transnational customary human rights law and transnational human rights adjudication. So let me turn to custom first. The transnational features of human rights transpire in the customary source of international human rights law to the extent that they give rise to a transnational intrastate practice constitutive of customary law. Now, again, a short reminder, customary international law is usually said to be created and or ascertained by reference to two elements: a general, regular, and coherent practice of states, and the conviction that that practice is binding as law. With the multiplication of states' practice and the difficult issues of evidence that follow, the two-element approach, that's how it's called, to customary international law, or at least their respective weight, have changed. Today, what we face are wilder, more modern, softer understandings of custom that are meant to contrast with wiser, classical or traditional accounts of custom. Some are based on opinio juris only and forget about the practice, while others privilege statements over practice. I can't address this debate in full here, but what's clear to me is that customary law, if it is to be customary, requires some form of normative practice to arise. And replacing this normative practice by statements, or worse, by the mere evidence of an opinio juris, does not fit the requirement of a normative practice. So I don't see how it could be different of customary international law. And to this extent, I do not see how customary international human rights law, provided there is such a thing as customary human rights law, could validly derogate from the two-element approach to customary international law. So in fact, I'll be quite classical on custom, but still, I would like to argue that customary international law is a source of international human rights law. So there are two concerns I need to address to make that argument. The first one is the alleged lack of general, regular, and consistent practice around human rights in the world. What I'd like to submit to you is that it's important not to overstate the practice. the difficulty. Custom requires state practice, but not necessarily state consent. So it's not because we don't get general ratification of human rights treaties that other kinds of human rights conform practices should not be considered. Moreover, the practice required for a custom to arise may be a practice of action, but also of abstention. Even though human rights are usually practiced by abstaining from violating them, this cannot be held against understanding those abstentions or omissions as practice when those are normatively motivated. Finally, single violations of a customary norm do not imply the non-existence of the norm unless the conditions for a new customary norm are met, and provided, of course, some degree of original compliance can be established. So I think justifications that are given for violation of human rights and the availability of remedies in case of violation count towards establishing positive consistency. So that's how I would reply to the first concern about the alleged lack of regular and consistent practice. The second concern, and that's somehow a debate that's still running between international lawyers, is whether the practice needed to establish custom needs to be interstate, or whether we could allow for intrastate practice to count as a custom constitutive practice. The problem, of course, as I've already said before, is that the practice of human rights owed primarily to people under a given state's jurisdiction cannot, or in a very difficult way, amount to interstate practice. Here in the paper, based on examples of customary international law developed in other fields of international law, such as the law of immunities, I bring evidence of intrastate practice being accepted as a constitutive practice of customary law. So I don't see how this should be different in human rights law. The second thing I should say, maybe to convince those of you who hold to interstate practice, is that the ILC has now accepted that the practice of international organizations is accepted as evidence of interstate practice of the member states. So in the case of human rights law, we have many international organizations that are specialized human rights institutions or have developed an important human rights monitoring activities. So if the activities in the human rights context of those international organizations is evidence of interstate practice of the member states, then we have evidence of an interstate practice in human rights law. So that was my argument for customary international human rights law. I realize I should say much more, but this is a lecture, so let me try to be brief. The second feature of the sources of international human rights law that reflects the transnational, domestic and international nature of human rights is adjudication. The mutual validation between domestic and international human rights law, I think, accounts for this very specific kind of adjudication one encounters in human rights law. Human rights adjudication is not like anything else an international adjudication. It really straddles international and domestic levels. Of course, human rights protection has long been monitored by international courts. Those courts or treaty bodies guarantee the respect of the minima consolidated in international human rights law. However, when one looks more closely at those international human rights courts' decisions, one sees that monitoring is subsidiary to domestic adjudication. International courts may only proceed with their monitoring once domestic judicial remedies have been exhausted. In turn, their review decisions are declaratory, thus calling for some form of domestic remedial enforcement. And finally, and most importantly for us, those international human rights courts may and should only offer new interpretations of international human rights law in the course of their monitoring activities when those are based on an existing transnational human rights practice. This is what I refer to as substantive subsidiarity. So they have to adapt their past interpretations sometimes when those no longer correspond to the existing transnational human rights practice. So What I mean to say is that international human rights courts do not work as ultimate interpreters or umpires of human rights law as a result. They're really unlike other international courts to that extent. International human rights courts should be seen rather, this is my claim, as facilitators of the self-interpretation of international human rights law by states. They help crystallize and consolidate states' interpretations and practices of human rights and the transnational custom stemming from the subsequent practice of human rights treaties. Once identified and entrenched as international law, that minimal human rights interpretation can then be reimposed on domestic authorities as international judicial interpretations of human rights. This is, I think, how one should understand the notion and the practice of European consensus in the practice of the European Court of Human Rights. What the court does is base its reasoning on states' general practice and their opinio juris. And based on that observation of a general practice and opinio juris of states, the court identifies a European consensus, some kind of interpretive custom among states parties. And this European consensus constrains the court's interpretation and guides it. In fact, if you read the case law of the court, you'll see that it does not only give itself the possibility to follow European consensus, but actually regards the reference to European consensus and following it as a duty. The evolutive nature of this joint or transnational interpretive process, by reference to consensus in practice, is sometimes also referred as the dynamic interpretation of international human rights law, and what I posit is that it's perfectly compatible with the VCLT, provided one sees it as the search for a transnational custom among states. So that was for my second point, focusing not so much on the objectivity of human rights as in the first one, but on the transnationality. The third point on the universality of human rights and the generality of international human rights law is briefer. This is how it should be. Okay, the first point's larger, the second one a little less, and the third one's much briefer. This is not to say that the conclusion will be easy, because it will be actually quite a strong conclusion, but the third point goes a little faster, because it's more, I think, more obvious. The third and final feature of human rights to be reflected in the sources of international human rights law is their universality. Human rights are rights all people hold wherever they are, and this accounts for the general dimensions of the sources of international human rights law itself. So human rights as universal rights. Human rights are best interpreted as the rights everyone has by virtue of their humanity. There are various articles, including Article 1 of the EDHR, who refer to human rights as the rights of all human beings who are described as born free and equal in those rights. The fact that they belong to everyone wherever they are is constitutive of their universality, whereas the fact that they belong to them by mere virtue of their humanity and not of another status, such as citizenship or nationality, is their generality. Importantly, the universal nature of human rights should be carefully delineated from the universality of human rights duty bearers. The universality of human rights pertains to the scope of human rights holders, and hence is about all persons having the same rights anywhere. It does not pertain to the scope of human rights duty bearers themselves. All states do not owe human rights duties to all people under whatever jurisdiction they are. They generate duties for every state, that's what's universal about it, but those duties are owed to those people's situation in a relationship of jurisdiction with that state, i.e. under its effective and regular normative control, whether it is territorial or extraterritorial. So that's what the universality of human rights is. Now, how does this transfer into the sources of international human rights law? I think it's reflected in the generality of the sources. Here, interestingly, note the semantic move. The universality of human rights holders, as I've described it, gives rise to the generality of human rights duties. They're owed by all states and are non-relative to some of them. So two qualifications are needed with respect to what the generality of international human rights law actually means. The first one, and here I'm moving closer to people interested in international legal theory, is a remark on the generality of international law and the sources of international human rights law. The generality of international law is a complex and ambivalent concept. It may be understood in three distinct and potentially, albeit not necessarily overlapping ways. One, it could be understood with respect to its subject matter, so lex generalis. The second one, sometimes, accordingly, it's understood with respect to the personal scope. So general international law is the law that binds all states, or all subjects, sometimes. Third understanding, general international law is understood with respect to secondary rules of international law, and especially to those regulating the sources of international law themselves. So general international law, in that third meaning, is the general international law on sources. Now, those three meanings do not actually overlap, and very rarely do so in international law, and that's what makes it very interesting. Here I understand in this section, I understand generality of international human rights law in the second meaning, i.e. international law that binds all states. What makes things complicated in international law is that not all sources of international law necessarily bind all states. This explains, I think, why general international law, understood by reference to its second meaning, so the law that binds all states, is also used by a further extension to refer exclusively to general sources of international law, like customary international law and general principle, that can bind all states. So those two sources are the only ones that may bind all subjects of international law, and this identification between general international law and customary international law and general principles, qua sources, actually explains, I think, why so many debates about the sources of international law are preempted, and why the debate about the sources of international human rights law is where it stands. By contrast, what I mean here by the generality of international law goes beyond saying that the sources are customary international law and general principles. As I will argue, the practice of human rights treaties itself also reveals traits of generality. So that was the first specification of what we mean, or what one ought to mean by generality, or could mean by generality of international human rights law. Secondly, the generality of international human rights law and the subjects of international human rights law. The question of the generality of international human rights law, as I understand it here, so the generality of duties for all states of jurisdiction, should be kept distinct from the question of the nature of the subjects bearing human rights duties. Following what I explained earlier about the relationship between meanings 2 and meaning 4 of the generality of international law, a common mistake is to think that because general international law in that second meaning may bind all subjects, then it necessarily does. In domestic law, we use two sources of general law being used to produce norms that do not necessarily bind all subjects. Domestic human rights in ordinary legislation is an example to point. Domestic legislation could bind all subjects, including individuals, but human rights legislation does not. It is a mistake, therefore, to assume that if international human rights sources are those of general international law in the second meaning, then it will necessarily bind all subjects of international law, including private actors. It is not because it can that it does, or that it should. In this section relating to sources, I focus on two features of the sources of international human rights law that I think can be accounted for on the basis of that universality of human rights. The first one is general customary human rights law. I think that's the most obvious feature of the sources of international human rights law to mention here. It's also the one that's most contested. People have contested the lack of generality of the constitutive practice, and I've already addressed this before with respect to general principles, so I won't rehearse my argument. And the second objection people have made to this argument for the general customary human rights law is persistent objection. And here is what I'd say in reply. I think persistent objection is an historical contingency, and is very rare today. More importantly, for human rights law, the justification of persistent objection lies in the protection of international legal human rights to the extent that it is the right to self-determination of newly created states that was protected by the institution of persistent objection. So it would be paradoxical, I think, to invoke a persistent objection to international human rights law itself. As a matter of fact, it's never been used, almost never in the context of international human rights law, and when it has, it's not been taken into account. When South Africa objected to the customary prohibition of apartheid, it was held to be in violation thereof all the same. And finally, in response to the concern expressed by authors about the lack of universality of the practice of human rights, although I think it can be assuaged, I think a third argument I could bring would be an argument of regional custom. I think international lawyers are ready to accept, and the practice does actually, that they are regional customs. And based on my second argument on the transnationality of human rights, I think the way we see human rights law develop is actually through transnational, regional clusters. We see this in treaty law. There are very few international treaties, or at least they were regional before becoming international. And I think we could argue the same about custom. This transnational human rights law and this international human rights custom has to evolve from regional customs. So this is a third argument I make in that section. Then I discuss the integrated Universal Bill of Rights. I won't say too much here, but they're basically two features of international human rights treaties that stand out from the perspective of the universality of human rights. One is that they work together as a network of treaties. This is what we sometimes call the Universal Bill of Rights, or core human rights treaties, or the system of human rights. And in fact, if we look at the practice of treaty bodies, even the ICJ or the European Court of Human Rights, we see how much they apply those treaties together. And by doing so, they expand the scope of duty bearers beyond parties to those treaties. So that's something that's unusual about human rights treaties, which I think can be accounted for on the basis of the universality of human rights. So let me conclude now, because I promised an interesting conclusion, including for those of you working outside of the field of human rights law. In this lecture, I have argued that the practice of international human rights law demonstrates three specificities in terms of sources that correspond, I have argued, to three features of human rights. Its sources are objective or non-consensual, and this corresponds to human rights' moral and legal nature. Secondly, they are transnational, and this corresponds to how human rights straddle domestic and international law. And finally, they're general, and this corresponds to human rights' universality. Those specificities were mapped in the lecture within the framework of the sources of general international law, and no new source of international law was identified in that context. There are four possible ways of explaining those specificities from the perspective of the sources of general international law, understood here in its third meaning, i.e., the general international law on sources. The first way to account for the specificities is to consider that they are compatible with general international law to the extent that the latter allows for cases of lex specialis. The difficulty, I think, as I've shown, is that many of the practices discussed in the lecture are actually derogatory, without a justification, and go well beyond the scope of lex specialis. So this understanding may account for some, but certainly not for all the specificities of the sources of international human rights law. Second approach to capture and explain those derogations within the framework of the general international law on sources would be to approach those unauthorized derogations from general international law as new rules or principles of general international law on sources in the making, or as established new rules. Again, this may be the case for some. What we've seen with reservations, for instance, is some of the derogations from the VCLT in the context of reservations to human rights treaties have today become accepted by states, including by the ILC. So this is a possibility, and we have evidence for this. But again, I don't think it's enough to capture the scope of derogations and specificities I've been discussing in this lecture. third approach, one may consider that the sources of international human rights law are so special that they cannot be explicitly or implicitly authorized as lex specialis, but have turned international human rights law into a self-contained or autonomous regime, i.e. a regime that literally is autonomous, so determines its own sources, and has turned into a system of its own. Now, this is what a lot of human rights lawyers claim and live by. The difficulty with this understanding is that international human rights law norms are regularly and at the same time interpreted systematically as the norms of a regime of international law and not as a self-standing system. So I think international human rights law amounts to a distinct regime to the extent that it has its own subject matter, but that it's not self-contained. Of course, a version of this third approach to the specificities of the sources of international human rights law may still be correct, and that version would run as follows. When the sources of international human rights law are transnational and become inseparable from those of domestic human rights law, as it is the case in transnational human rights adjudication, for instance, one may argue that human rights law is no longer international. There is no point then in even considering international human rights law as a regime of international law, and even less so as a self-contained regime. But that again would not please all human rights lawyers. Finally, and much more radically, one may consider that the specificities of the sources of international human rights law have turned it into general international law. What looked different about international human rights law may in fact be standard. This may be because consensual or reciprocal, interstate, and relative international lawmaking has become rarer than it used to be. As a matter of fact, many of the features discussed in this lecture are shared by an increasing number of norms and regimes of international law. Think of legislative treaties, interstate custom, development of soft law, judicial lawmaking. But maybe not. Maybe the boot is really on the other foot, that of general international law itself and its existence in the first place. If there is general international law of sources at all, its sources have to be objective, transnational and general. For it to be general in a meaningful sense, its material and functional generality requires that at least parts of it be made independently from consent, be anchored within domestic legal orders, or at least in some form of inclusive or even democratic process, and finally be universal in scope. If that is so, then international human rights law is the central case of general international law, to the extent that they can be general law and international law. This fourth interpretation, I think, is the right one, at least for the specificities in the source of international human rights law that may not be accounted for on grounds of lex specialis rules or that have not become general rules of general international law. If I'm right, international human rights law is the new general international law, and so are its sources. They've become the sources of the general international law on sources. Thank you for your attention.
Thank you very much, Samantha. So we have about 20 minutes for questions, thoughts. Professor Giudice, I'd ask you to make sure you have a microphone when you ask your question, again, for purposes of recording. Thank you.
Okay, thank you. That was wonderful. I mean, that fourth conclusion sounds quite interesting, and would love to hear how. Maybe not all today, but that's a fascinating thought to end with, I think. I want to ask a question a bit earlier about the conception of human rights as legal rights, and in particular, I can see how. I should say first, thinking about human rights law in terms of legislation or with legislative dimensions, I think that's a really nice conceptual move, a good way to think about their objectivity as well. I guess my question was about thinking of international human rights as legal rights. And particularly, I can see how you could think of legal rights, human rights law, as legal rights within the international legal order. So thinking within international law, human rights treaties as having these legislative features to them and being accepted, I guess. So that would be the key, I guess, the key evidentiary move would be to think about how they are recognized and accepted within international law. So you kept mentioning about, there's a growing consensus among international lawyers and international legal scholars. But I guess it's harder to think about, or I guess it's harder for me to see how the evidentiary move would be made to say that human rights, international human rights law also constitute legal rights within domestic legal orders. I mean, there it seems like the evidence of recognition would be much more messy, varied, shifting, sometimes occurring in backward steps. So I'm just curious about that move. So I can see legal rights as human rights as legal rights within international law, but it's more difficult to see whether that also constitutes an argument for saying there are human rights or legal rights within domestic legal systems as well.
Thanks a lot, Michael. First, I should say that I'm really getting jet lagged, so I hope you'll bear with me here. I take it that your question pertains not so much to the objective claim about the legal nature of human rights, but more to the practice of it, right? That's how I understood the. Yeah.
I guess because you get mentioned the practice of international human rights law, and I guess there I want to pause and think if there is a single practice or whether it's plural, diverse practices that might exist.
So, I think you raise a really important question, and it needs to be settled positively for the argument to work. I think one way to do so would be to see that. In fact, we've, as international lawyers, really resorted to the judiciary. This may be a little skewed and too limited, but this is usually what people do. They go for courts and domestic judicial evidence as evidence because it's written. The reasoning corresponds to the kind of reasoning you need for human rights and so on. So people usually will go for domestic judicial decisions. So that would be the place to go. Now, who would be actually caring for or actually doing this work, this transnational, this comparative work? That's an enormous task. You're right. And this is probably why we can't really find criteria, a clear method within the evidence that we have of this jus commune of human rights, or this comparative, or this transnational constitutional law of human rights. What we have are international decisions, mostly regional, that will use some comparative law method to identify some domestic judicial practice. But it's usually judicial, that's I've already said, and it's never complete, and it's a very slow and enormous project. I suppose that if some states feel that their practice has not been rightly identified or reflected in the consolidation of that consensus by the International Court, they have a chance to say so. And in fact, clever states have started to do that. So when they see that the understanding of the domestic practice that's consolidated by an international court is not something they're part of or not something they understand as such in the domestic legal order, they'll say so in the next case. And they'll explain this, and this way contribute to rectifying it. But I don't know if all this somehow helps to show that it could be brought, I think. This evidence could be brought. But a fourth response I could give is that it probably explains why we need to start at the regional level. And this is where it's starting. This is where the courts are, the international courts are. They're regional. There's no universal human rights court. So the ones doing the work of identifying this practice, this transnational domestic practice, our regional courts. But it's also more feasible. So I suppose that's it. But does this, yeah? No. Okay.
Other questions? Professor Bob, just make sure you get a microphone. Nathanson.
Thank you for the talk. You started by refuting the view that international human rights is basically shares the same sources as public international law, or is simply a product of a broader field. You ended by suggesting that international human rights might actually be occupying that field. I wonder if you could speak to your normative agenda, and what is your concern with insisting on specificity and then hinting at creep?
Thank you very much. First, I probably didn't express myself sufficiently well, but I didn't start by refuting that they share the same source. I started by saying that a prima facie, quick observation of the field shows that there are derogations. That those derogations need not imply new sources. In fact, I've shown that there are none of those new sources. Some of them may be justified, some may not be justified, and so on. So the point of this, I think that's the second remark I made in the introduction, was basically just to start by saying we're going to be looking at what's different. But what's different could be very different, not very different, sometimes justifiably different, sometimes not justifiably, etc. So it's really an open, the agenda is really open at the beginning, and then as you said, I conclude that it is different, but not so different, and there are many ways of understanding those differences. Now, so I think this has rectified the misunderstanding. Now, your second question was, what agenda is there?
Well, my first question was a provocation.
Yeah, sure. But I better replied.
You feel you've did you respond to it as a provocation or as a misunderstanding?
I think it was not only a provocation, but you said I started by stating they use different sources, and I didn't state that. So I think there was partly a misunderstanding, and partly, of course, a provocation. So I suppose the provocation comes from the fact that what I see in the field is I see general international lawyers saying there are no problems with the sources of international human rights law. We can all fit them in the same box as the rest of international law. And those human rights lawyers are just human rightsists, crazy differentialists. You know, they should stop saying nothing of what they're doing can be fitted in general international law. So that's what I see among general international lawyers. And they can't even recognize the controversies within the sources of general international law. Many of the things I discuss in the lecture are actually problems for general international law, not so much for human rights law. So that's what I see on one side. And on the other side, I see human rights lawyers who just like being different and don't really question what's so different, how is it different, how could we justify those differences, and so on. They generally start the argument by saying it's self-contained. So that's my starting point, seeing this field that's somehow divided to that extent and trying to bring those people back together, because I'm both a general international lawyer and a human rights lawyer, and I care for this, and I think this makes our work as human rights lawyer better. So that would be like the further agenda, if you want. But more directly, the earnest answer to your question is that this is a chapter for a book on the sources of international law. And it belongs to a section where we ask the authors to discuss the sources in so-called regimes of international law. And then they can have many different agendas. Some will have separatist agendas, and some, on the contrary, will have inclusive agendas or whatever. So I think this maybe gives you a little background to how this lecture fits the paper world, the world of written articles and chapters. Yeah, but I don't think you please, because you want more provocation.
No, you've responded.
Okay.
Fine, thank you.
Okay.
I have a quick question myself, and I'm going to go to Professor Igneski. So in theory circles, people talking about human rights, not so much in terms of sources, but in terms of legitimacy, there's somewhat of a consensus emerging that we've moved from a world in which the legitimacy of international law not so much hangs on a concept of sovereignty and sort of enclaves of territories that are immune from interference from other such enclaves of sovereign enclaves, to a world in which human rights are really at least an important beacon of legitimacy. Right? So it seems to me at the level of legitimacy we've moved from something else to human rights as being the criterion, or at least one of many criteria. At the end of your talk, you say, well, maybe we've moved from a world in which the sources of international law are now to be best understood, not so much in terms of what they were understood to be, whatever that is, to a world in which general international law, as it were, and its sources are best understood in terms of the sources of human rights. Do you see any link between these two movements?
Thanks, François. This is interesting, and yes, it's not explored sufficiently now, but it's an interesting thing I could push. Absolutely. When you start thinking of human rights law as any kind of international law, you know you're already doing something that impoverishes the way you address the topic, because it actually has a function with international legal order that's not the same function as other regimes. And this may actually explain why its sources have another function than the sources of other regimes, of course. But I was trying, and this is what I flagged at the beginning of the introduction, I was trying to keep the legitimacy question outside of the topic, and so did I with the moral grounds. But of course, to get the full puzzle, we need to bring those two things back together. The legitimacy, as you just did, and the moral grounds. I addressed the latter a bit through the natural law, legal positivism debate, but it's far from enough, of course, because there's probably a lot of power that could push back and ask me to do much more than that. So you're right. You need the two other pieces in the puzzle to have a full view. So that could be brought in another page in the conclusion, probably.
Because my very pedestrian observation was simply that if it's very important in one way, then it's likely that that's going to have effect in others, right? If we're talking about international laws being the source of legitimacy, human rights being the source of legitimacy, then suddenly people are paying more attention to it, and then that becomes maybe,
That's exactly what we see. Yeah. The paper I presented here in 2009 about the legitimacy of international human rights law was exactly about this, right? So how could something be have a legitimate authority when it's itself the basis for the legitimate authority of other things? And in another paper I wrote, which I didn't present here because I don't live here, on the justifications of international human rights law, which is the third piece of the puzzle, there again, I tackle this problem of justifying something that's justificatory, and the self-justificatory nature of human rights, and the fact that they are justificatory in themselves, makes the task of justifying them even bigger. So, yeah.
Professor Igneski, if you can get hold of the microphone.
Do I need to do anything to it?
No, you just talk.
Okay. Okay. Thank you for your talk, Samantha. I was very interested in the first part when you were talking about how you saw it the human rights at once as having this moral and legal nature, and I thought that was a nice and I think a different way of putting it that I liked. And my question isn't about that feature, but in light of seeing human rights in that way, I had a question about the generality, the feature of their generality, and the limited way in which you talked about their generality, and not just the way you talked about it, but the actual practice, and that was their generality with respect to the scope of the rights holders, and not the scope of the duty bearers. And I just wondered, so the duty bearers, those would be states with respect to the people underneath their jurisdiction. But is there any reason for that, the limitation on the generality? Is there any prospect of expanding that so that it would be more general, so that the duty bearers could be as general, that category could be as general as the rights holders category?
Thank you very much. Yes.
I've noticed that there's just one more question in the room, so why don't we take it and then you can field them together. Jorge Fabra, if you can.
Thank you so much for the talk. I'm just going to raise a question concerning this distinction that you raised at the beginning between the legal aspect of the moral right of human rights and the moral aspect of human rights. I'm really puzzled about this. I take you to be arguing against this orthodox view where the human and legal, the moral and legal nature of human rights are conflating, and you want to make sense that there is a moral concept of human rights and a legal concept of human rights. So if that's the case, there is this possibility that I believe this right, that there are legal human rights which are contradict or moral human rights, and I believe this is a correct view. But there is also this intuition of the orthodox view when we try to account how something can be a legal human right. So, for example, if we think in Russian terms or in positivist terms, like let's say that something is legal if it's content independent. So how can it be, if that's the case, how can it be something like a content independent human right? See, if it seems to be something about the nature of human, of something to count as a human right that is content dependent, that it depends on its merits. So I am puzzled about how do you draw the difference between legal moral rights and moral human rights when you are about to explain its legal nature.
Thank you very much. So two questions, great questions, coming after all those great questions. So as to the first one, it's a very, and I was speaking quite fast, I know. It's a very subtle distinction. I don't want to say that generality and the universality of human rights does not imply that the scope of the duty bearers of human rights is not universal. It is, but duty bearers being states. And the full argument for this is not provided in this paper. It's an argument about why, to be a duty bearer of a human right, you need to be an institution. And why private actors and some international organizations, most, do not yet have the necessary institutional features to be duty bearers of human rights. So that's a separate argument that I've made elsewhere. I'm not excluding that other international organizations may not gradually become like the EU and bear human rights duties, but I'm certainly excluding this for individuals. So it's a separate moral argument based on institutional features and based on an egalitarian account of human rights, basically. So it's like a big argument. And I've written a paper, and it's coming in the Journal of Social Philosophy. It's forthcoming soon. So you ask whether there's a prospect? No, I think conceptually, as I said, it's not a matter of prospect. Okay, so I think I've clarified this distinction between the universality of states as duty bearers of human rights and the lack of universality of duties for all subjects of international law. And the reason I talked about this in the paper is because many human rights lawyers assume that because the source of human rights law is general international law, in the meaning number 2, general international law that binds all subjects, then because that source is general international law that binds all subjects, then human rights law will necessarily bind all subjects. And as I explained, it's not because it can, that it does, or that it should. That was the mere reason I discussed this here. But you're right to say that this is a fantastic question, and the full argument is elsewhere. So thanks for raising it. Now the last point, I really see the relationship between those two dimensions of human rights as being mutual. So they're not moral rights first and then maybe legalized as human rights. They're moral and legal. So that's the claim. And the relationship is not only mutual, but it's not unilateral. It goes both ways. So that's the claim, and you're right, it's a claim against some of the orthodox view. It's very difficult to know exactly where people stand today. It comes closest to Raz's view, probably, of human rights. Although we'd like to hear more about his view after 2010, and we've not heard since on the view, but it comes closest to Raz's view. So it basically uses Raz's notion of rights and considering legal rights as moral rights for them to be rights. So it falls with Raz, basically. If you want to undermine Razan's theory of rights, then this falls with him. But again, I've argued for this in the book, in a chapter on the structure and the nature of human rights. So it builds on a Razian account of rights, and then it brings this in light of democratic account of human rights to bring in the democratic and egalitarian dimension of law into the picture. So that's the making of this account that you heard very quickly. So I think you now have seen that account in its underwear. Yeah. So I hope it helps understand where it comes from. Yeah.
And putting the name of Joseph Raz forward as an answer to a question is one way of just stalling any further discussion, and that's great because
that was not the point. Sorry, I didn't mean that.
We've now run out of time. So please join me in thanking Professor Besson for a wonderful lecture. And here's a little token of our appreciation. Very little.
Thank you so much.
So
thank you.
we hope it'll fit in your suitcase. Thank you very much.